is welcome to come forward. And to avoid confusion, these next two cases, the plaintiff is Burd in both cases. This one is B-U-R-D, and in the next case it's B-Y-R-D, so hopefully there won't be any confusion. Good morning.
Good morning, Your Honors. My name is Kristen Shields, and I, along with my colleague, Mr. Christopher Beverly, have the privilege of representing Mr. Kenneth R. Burd, Jr. We're here in Middle Tennessee, and in their erosion world, he's known as Kenny. I request 5 minutes for rebuttal, please.
5 minutes, very good.
We are here because a client trusted his attorney and the information that his attorney told him that induced Mr. Burd into signing a restrictive covenant agreement that should be invalidated. That confidential relationship is at the heart of this matter, and it's something that the trial court did not fully recognize. She did not give the full meaning of the confidential relationship that is set forth by law that both appellees, Richey and Smith, had with Mr. Burd for years prior to the transaction at issue ever coming about. The trial court erred in two key ways. First, by granting the defendant's motion to dismiss and holding that Mr. Bird's claims in his first amended complaint were the same as in the original complaint, and that they were barred by the language of the release. Second, the trial court erred by requiring Mr. Burd to tender back funds to proceed with his case on the first amended complaint, and by failing to recognize an applicable exception to the tender rule. The trial court, as I mentioned, failed to fully recognize the specialness of the confidential relationships, namely the attorney-client and accountant-client relationship that existed with Mr. Smith and Mr. Burd. And that is really the leading foot in this entire analysis. Because of that relationship, the RCA, the Restrictive Covenant Agreement, I'll refer to RCA for short, is inherently invalid, and there's a presumption of invalidity that governs this entire transaction. Our ask is as follows of this court: invalidate the RCA and reverse and remand, instructing the trial court of the invalidation that Mr. Bird's claims in the first amended complaint are not barred by the RCA and that he does not need to tender any funds to proceed with his case.
So it sounds like you're characterizing this as almost like a legal malpractice case. Is that fair to say?
The first amended complaint involves a tort action where Mr. Burd has alleged tort claims of breach of fiduciary duty against the appellees who independently from one another owed those independent duties to Mr. Burd. And so there are different avenues. There were a lot of different wrongs that occurred by appellees surrounding this transaction.
Yeah, but it sounds like, I mean, based on your introduction, it sounds like a lot of the fault you're placing on Mr. Smith here.
There's no doubt that he is the leading bad actor. Now, when Mr. Smith
and your client is positioned with him as attorney-client, is what
Yes.
you're suggesting. So, how do you explain the clause in the covenant agreement that says that he has consulted your client has consulted independent counsel? So he didn't do that?
So Mr. Smith, correct. Mr. Smith did not, as he had a duty to advise Mr. Burd that this was not a fundamentally unfair transaction on its face. Mr. Smith had a duty to independently advise his client, Mr. Burd, that he had the right to seek outside counsel. Mr. Burd had the right to full and frank disclosure of all relevant facts.
But one of the things he represented when he signed this agreement was that he had independent counsel, and you're saying that wasn't true.
Mr. Smith characterized this RCA as something entirely different than what it actually was. And it's those misrepresentations on which Mr. Burd reasonably relied to his detriment that caused the RCA to be invalidated. And so when we look...
Wouldn't the better course for your client in this instance have been to read that agreement? I mean, it sounds like, what you're telling me now clearly conflicts with the representation your client made in the agreement he signed.
So Mr. Smith, when he sat across the table from Mr. Burd and presented this document, there was 8 years of attorney-client relationship and accountant-client relationship that predated this transaction at all. And so the transaction at issue is fundamentally unfair. Now, when we look at the fairness, the advice of outside counsel is just one of many prongs that render this transaction unfair. Was there a full and frank disclosure? Did Mr. Burd receive adequate consideration? So the adequate consideration is, of course, a fact piece that would need to be fleshed out at the trial court. But as far as the full frank disclosure, Mr. Smith sat across from Mr. Burd and made 3 material misrepresentations. He abused his attorney-client relationship, that trust of 8 years. We alleged in the First Amendment complaint that Mr. Smith had his own business, Sterling Consulting Services, and through that he provided Mr. Burd independent legal and accounting advice. And those 3 misrepresentations are as follows. Number 1, that the purchase price was very different than what it was. It was millions less. And keep in mind that Mr. Burd, just as an indication of the lack of information that he was provided, is he wasn't even provided a copy of the unit purchase agreement. That only came into anybody's possession after litigation was initiated. So the only thing that he was presented was this RCA, not the entire details of the transaction. He would not have signed it if he had known, and said, here, sign this, as his attorney and CPA had done for years prior.
So your client would not have signed the restrictive covenant agreement if he was aware of the unit purchase agreement?
1,000% not, because
So why wouldn't the second paragraph of that restrictive covenant agreement be a tip-off to your client? There's a unit purchase agreement.
Because he was relying on what Shay Smith was telling him as the leading
rather than
foot.
reading the agreement.
Because this is somebody that for 8 years who was his personal and family's lawyer, who had on personal matters advised Mr. Burd on other business transactions that Mr. Burd would engage in. And so not only did Mr. Smith misrepresent the purchase price, which as we know is a material part of a transaction, by millions, but he also misrepresented that Richey and Smith were staying on after the sale and that they were receiving ownership in the company after that sale. And who benefited from all that? Richey and Smith. And so Mr. Smith was padding his own pocket, abusing his relationship with his victim client, which is terrible in and of itself, but that's why the RCA
Did
is
your
invalidated.
client play any role in the conversion of the corporations into the LLCs?
He did not.
Okay. So, no, he wasn't asked for consent to do that conversion.
He was not. And so the reason we asked this court to invalidate the RCA and to take the approach set forth in the Riviera case that the trial court did not do is to recognize the abuse of the fiduciary relationship and the ramifications of that. And so the trial court really treated this like an action for rescission, which it's not. We even clarified with the trial court that we did not seek rescission in the First Amendment complaint. And so the trial court puts us in a lane that we're not. She puts us in a lane of more of a breach of contract action, rescission, and with rescission, tender back comes on the table, potentially. We're not in that lane. We're in the lane of invalidation, that because of the confidential relationship, which this court recognized in Riviera 22 years ago and still stands today, that the transaction at issue, meaning the signing of the RCA, is presumptively invalid. And so because of that precedence, we don't have to tender back. The Riviera case says we can use invalidation as a sword because the dominant party, meaning the appellees, and let's not forget Chris Richey too, because there was a 20-year relationship with Chris Richey before this transaction. We pled all of this in our First Amendment complaint. Started out as friend, doing life together, raising children together, as a friend, confidant, trusted advisor. And Chris Richey and Mr. Burd had other businesses together, which we alleged in our First Amendment complaint as well, outside of this. And so Chris Richey had a duty stemming decades before this transaction at issue. And then, as we alleged in our First Amendment complaint, starting in 2013, Shay Smith began providing legal and accounting services to Mr. Burd. And so in this stair-stepper analysis, We have invalidation first and foremost, and we ask this court to invalidate this RCA, or at a minimum, instruct the trial court that there is a presumption of invalidity, per the Riviera case.
So how do we invalidate agreement if the other party is no longer a party to the lawsuit? Your First Amendment complaint drops out Greenrise Technologies, correct?
That's right.
But they're the other party to the RCA, so wouldn't they have to necessarily be a party for us to grant the relief that you're asking for?
They do not. The appellees are third-party beneficiaries of the RCA, and so regardless of who the parties of that RCA, when it's promulgated by fraud, by abuse of this type of relationship, it's invalidated right then. And I want to clarify also what our First Amendment complaint does. As I mentioned, it's a tort action against Mr. Byrd's individual tortfeasors, who each owed individual duties to Mr. Byrd, irrespective of the other appellee. And if found liable for these torts, then at the trial court we would have a damages hearing. And so we are not leading with the foot, as appellees would like you to believe, that we're trying to just get our shares back of the business. We're not. Or get a sum of money. We're not. We're trying to hold the appellees accountable, and then at a damages hearing there would be a whole host of things that we would present. The delta of anything extra that Mr. Byrd was owed stemming from this fraud is just one of many things that would only scratch the surface of the harm that he's experienced at the hands of appellees, namely Mr. Smith, who was the leading bad actor, but Chris Richey was also sitting across the table from Mr. Byrd during all of this and never corrected any of the false information. And who benefited from this? The confidential trusted persons who were padding their pocket, lying to Mr. Byrd, who that's a fundamentally unfair, illegal transaction on its face. And so we don't have to get to whether any claims, any persons are released by the RCA, because the RCA is invalidated, and we don't have to get that many stairs down into that level of analysis.
All right, thank you, Ms. Shields. We'll hear from you
I'm sorry.
on rebuttal. Mr. Knight. Good morning, sir.
Good morning. Thank you, Your Honor. Stephen Knight for the appellees, Mr. Richey and Mr. Smith. I'd like to start out with a pretty fundamental point, which is what is the issues, or what are the issues that are before the court? From counsel's argument and from Mr. Byrd's reply brief, it sounds like the question is whether the restrictive covenant agreement is enforceable at all, and therefore that would implicate the tender back rule. That's absolutely should not be before the court. Even in the reply brief on page 18, they state that there's no claim for rescission. Now, it sounds like counsel maybe is drawing a distinction between a contractual claim for rescission versus breach of contract. You know, you can enforce an agreement or you can try to rescind it. But there's no distinction between an invalid, if you invalidate a contract for any reason, fraud, breach of contract, you have to rescind it, right? If I'm defrauded into purchasing a house and we void the contract, I don't get to keep the house. I mean, rescission is part of that, and the tender back rule then comes into play. Just to finish the point, in their initial brief, on page 38, Mr. Byrd says, a plaintiff is not required to tender back the proceeds of an agreement where the plaintiff affirms the contract, as in this case. The whole premise of this appeal is that they're affirming their restrictive covenant agreement that has the release agreement, and they're saying it doesn't apply. That was their original argument. That's in their initial brief. And again, in their initial brief, they just flat out say it. On page 38 again, appellant's claims on appeal all affirm the validity of the RCA. What happened in the trial court, the way we got here is, of course, there was this original complaint, sued all the companies, the buyer, the individuals, and one of the arguments in the motion to dismiss was that Mr. Burd had not offered to tender back the proceeds that he received from this transaction, and therefore the release provision was enforceable without that. In order to try to cure that, Mr. Burd non-suited most of the parties, filed an amended complaint not seeking rescission, and argued to the court, we don't have to tender the money back because we're not trying to rescind the restrictive covenant agreement anymore. We're just arguing it doesn't apply. This part, Mr. Burd and Mr. Richey and Mr. Smith are not releasees. These are not released claims. And that's the basis of the appeal. The initial brief, the argument that it's making is about interpretation of the release provision, right? Are these releasees? What about these commas? That sort of thing. I don't know whether Mr. Burd is abandoning that argument about the proper interpretation of the release provision.
Well, let's focus on that then. I'm interested in the argument about whether or not your clients fall within the definition of releasees under the release.
Right.
That is a paragraph in desperate need of some different punctuation. What category do your client, or categories,
Right.
does your clients fall within in the release?
Well, yeah, one of the odd things about about Mr. Bird's argument is, I think even if this strange interpretation that he proposes is correct, Mr. Burd and Mr. Smith would still be releasees. There's so many that I've got a list here, but so Mr. Richey was an owner, and at the time of this agreement, so he was a past and present owner of Old Erosion and Old Products. He held an indirect interest in New Erosion and New Products. He owned a company that was a member of those,
Right, but
the converted companies.
Is owner listed? I don't think an owner is one of the listed.
Well, members.
It's member.
Right.
Which, I mean, I'm assuming since Richey and Smith took a interest in after the conversion as members, they would be present members, right, of the company.
I think technically Mr. Smith was a member. Mr. Richey owned an LLC that was a member.
I see, okay.
But I think really, I'm kind of going in order, but I think the easiest ones are, the whole time they were employees, agents, representatives.
Okay, and I guess that's my question is, how do we get that? So we've got to go off just the complaint, the First
Right.
Amendment complaint.
Right.
Is it alleged in the First Amendment complaint that your clients were employees so that we can say on this, it fits squarely within the release?
So two things. In the memorandum, it was uncontested, for what that's worth. The memorandum in order references all these things on pages 523 to 527 of the record. But as far as the complaint and the amended complaint, the unit purchase agreement itself, which is Exhibit 1, the recitals set this out.
Okay, so the unit purchase agreement is something we can consider then because it was attached to the First Amendment complaint?
Right.
Okay.
And I would also point out, from the trial court all the way through appeal, Mr. Burd has never contested that they fit into all these different categories. I'd also point out, with respect to the releasees, this is an issue that's not properly before the court. It wasn't raised in the trial court, and in fact,
if we can get past that issue,
Okay.
I mean, again, so this is de novo review, so we're looking at this fresh. It's just a question of law. I mean, it seems difficult, and we're just seeing if a claim has been made out. Is there any other categories that we need to concern ourselves with releasees? I don't want to, if we eliminate one, I want to make sure we've looked at all you're asserting are potential releasees here. So employee is one. What are the others?
agent and representative. And also, to some degree, owners and members, with respect to as we argue, the old company before the conversion and post-conversion are the same company. So the allegations of the complaint certainly allege, for example, that Mr. Richey was
Although
an owner.
Mr. Richey ended up forming a holding company, correct? Placing the stock in both the old entities into the holding company, and then converted the two corporations, or two S corps?
I'm not sure whether they're S corps, but they were corporations.
Okay. S corps into limited liability companies, and then the membership interest in the limited liability was held by the holding company.
Right.
Okay.
But before all that, originally, he was just an owner.
All right.
And again,
That would be passed.
well, it's the same company. Oh, well, right,
I'm
past.
trying, yeah,
Right.
I'm focusing now,
Right.
here's what I want to drill down on, is releasees. That was argument made in the brief. I just want to make sure that as I'm looking at the complaint, the attached documents, that the court can analyze each category you fit in. So far I've got employer, agent, representative, owner, and members.
Correct.
Okay.
And with respect to
Director and officers?
I don't know that that's in the record.
Okay.
I'm sure that they were, but I don't know that that's in the record. With respect to the actual interpretation question, whether their interpretation is correct, there's two things. One is whether buyer is its own thing, and then the company and its successors, so on, is a separate
That's
thing.
what this morning is missing, is an Oxford comma discussion.
Correct. Well, now we have it. And I think speaking of that, there's sort of a presumption in their argument that the drafter of this agreement uses the Oxford comma. It doesn't take very long looking at this agreement to see that's not the case. There are a few isolated instances where it is used, but for the most part, this agreement is not drafted with the Oxford comma. But even if it were, the appellees are not related to the buyer, they're related to the companies. So the companies, past, present, future, successors, predecessors, agents, and so on. So they would be included in that. So then the second question is past, present, and future. Mr. Burd argues, well, for some reason, that modifies only the first item on the list, successors. Past, present, and future successors, and presumably, by implication, present agents, predecessors, and so on. That, aside from the fact that there's no rule of grammar that would require that, the Oxford comma only would relate to whether past is one thing and present and future are one thing and two things, or two things, right? There are definitely two things if there's a comma. In some cases, there might be an ambiguity without a comma. In this case, there's not really an ambiguity. With their interpretation, you get bizarre results. First of all, why would successors be singled out for special treatment? Past, present, and future successors, but these other things are not past, present, and future. That doesn't make any sense. In addition, you get strange things like past successors. What does that mean? Present successors. 2 out of the 3 don't make sense with respect to successors under their interpretation. Now, they point out, you can say the opposite, that under our interpretation, you have like future predecessors. That's true, but if you look at this release provision, very long, very comprehensive release provision, obviously what is being done here is every conceivable permutation is being covered. It's over-inclusive. It includes some entities that can't possibly exist. No matter which way you interpret it, that's the case. But if you look at it throughout here, everything is past, present, future of any kind. We're all familiar with these kind of release provisions, and obviously the intent of this is to be as inclusive as possible. So for many reasons, and even under their interpretation, Richey and Smith are releasees. The second question of interpretation has to do with released claims, and that was really the argument that was made in the trial court. This releasee was not made in the trial court. But the definition of released claims is, again, past, present, or future in law or equity relating to, arising out of, or in connection with any claims that the restricted party, Mr. Burd, may now have or may in the future have against the company or the respective subsidiaries related to events before the effective time. Now, you could imagine a case where we would be here arguing about, well, are these claims related to a claim that Mr. Burd may now have or may in the future have against the companies? We don't really have to speculate about that because the original complaint says that the case arises out of a conspiracy involving the company and all the defendants, including Mr. Smith and Mr. Richey. So these claims are clearly arise out of claims that could be brought against the company. In fact, were brought against the company and are now no longer pending. But in addition to that, again, consistent with this practice of trying to be as inclusive as possible, we don't have just arising from, related to, in connection with. I mean, this whole document, it says in the recital that this is related to the sale of the company and to facilitate that sale. Of course, a claim that you were defrauded with respect to the sale, that's a subject matter of the agreement. That's one of the released claims. That's in connection with a potential claim against the company. That's related to it. So in response, Mr. Burd cites several cases that say, once you have an amended complaint, the original complaint goes away. You have to read those cases in context, of course. It's always possible to take language out of context. It doesn't mean that the original complaint was never filed or that can't be used as an example of a potential claim against the company that would be related to the claims that are being made against the appellees here. The McBurney case had to do with, there was a complaint was filed, there was a motion to dismiss, an amended complaint was filed, and there was no appeal. Well, the amended complaint was never challenged. The Court of Appeals said, well, it doesn't matter whether the original complaint was subject to appeal, there's an amended complaint. The Henson case was a medical malpractice case. The plaintiff filed against a number of doctors. The answer alleged comparative fault. Then there was an amended complaint that dropped out several parties, and the only point in that case was the original parties are no longer parties. Only the parties in the original complaint are parties. So those cases aren't really applicable. The original complaint is an example of a potential and actual claim against the company related to the claims against the appellees in this case. So I would just, in closing, just ask the court to focus on what the issue really is in this case. Mr. Burd has said that they affirm the RCA, the restricted covenant agreement with the release provision. They shouldn't be able to come back in the reply brief or an argument and say, well, maybe we don't. Maybe there was fraud and tenderback rule shouldn't apply for that reason. Thank you.
Thank you, Mr. Knight. Ms. Shields, your rebuttal.
Thank you, judges. I want to correct a couple misstatements in Appellee's argument. First, that invalidation and rescission are the same. This court has recognized that they are not two and one and the same, and the differentiating factor is that confidential relationship. You described in Riviera that the piece that makes this special and different from any type of rescission action, we never claimed that this was a rescission action. I vehemently disagree with Mr. Smith on that point, but the original complaint was destroyed despite being continually referenced by appellees and the trial court as we were fleshing this out in January of 2023. But going back to this court's question on the independent counsel piece, Mr. Burd believed he had his attorney, his own personal attorney, sitting at the table with him. He thought his independent counsel was sitting right there. His independent counsel, he did not know that Mr. Smith was going to, after, as we see in the unit purchase agreement, after this transaction, become an owner in the business. He didn't have the unit purchase agreement. And so there were material misrepresentations that led him to sign that. But He did not know that Mr. Smith had an interest in this business that was coming about after the sale because he wasn't provided the UPA. In the Riviera case, even the most astute business people are not experts on every aspect of their trade. They relied on the guidance of their skilled professionals. So, notably, in the RCA, you touched on who is released under the RCA. Frankly, it doesn't matter. I'll make this even simpler for the court because there are 3 prongs in the RCA. Again, the RCA is invalidated because of the abuse of the confidential relationship. But let's say for argument's sake that it's on the table. There are 3 prongs of the RCA: who, what, and when. So the horrible punctuation in the drafting of the release, which we did not do, we can bypass that in a way and look at the subject matter and the timing aspects. So let's talk about the subject matter first. What would be contemplated as released? Individual claims that Mr. Burd has in the First Amendment complaint against his individual tortfeasors who owed him a duty. Take Green Rise out. This could have been a purchase of a Kroger or an investment in a Krispy Kreme. It doesn't matter, because the individual duties existed long before this transaction, through, and even after. And so the trial court erred by saying, well, in January 2023, when we were here on plaintiff's motion to alter or amend and defendant's motion to dismiss the First Amendment complaint, the trial court said, well, haven't we been here? Like, the First Amendment complaint is the same as the original. I haven't read it word for word, but piggybacked very much on a destroyed complaint. And so the trial court failed to recognize that these individual claims, these individual torts against his tortfeasors, were separate and distinct from any potential claims against a company or business, because those duties were owed to Mr. Burd, independent and apart from that, decades before with Mr. Richey and 8 years prior with Mr. Smith. And then I'll point out a key part also regarding the timing. The release fails on the timing part. Timing is defined in the UPA as the date of closing. So for ease, mid-November. We alleged in the paragraph 31 of the First Amendment complaint that Smith provided legal and accounting services through the end of 2021. Meaning, after closing, no claims are released after closing. After closing, Smith and Richey continued to owe these duties that they violated every single day, that they failed to correct the false information that they told Mr. Burd to pad their own pockets. So we alleged in the First Amendment complaint, paragraph 31, ongoing violations after the date of closing that under no circumstance are barred by the release. We are asking this court to invalidate the RCA, at a minimum reverse and remand, instructing the trial court that there is a presumption of invalidity that appellees would have to overcome through clear and convincing evidence. The tender rule does not apply, and if you feel it does, an exception should apply because Mr. Burd received funds that, according to the filings, no one disputes that he's entitled to at least that amount. But again, that would come out at a damages hearing if the appellees were found liable. So we are asking this court to reverse and remand for those reasons. Thank you.
Thank you, Ms. Shields and Mr. Knight, for your argument. We will take this case under advisement. Call the next case, please.
Rebecca Burd versus Clarksville Montgomery County School System.